Joseph Mulingo Nzau, John Mulingo Nzau, Mark Amiani, Francis Mtunge. Kindly take your seats. The quorum purposes who are before me today. The notice of motion filed on 30th of June 2025, in which the applicant, who is the Republic, seeks for orders. The first order is spent. The second order is that to facilitate the completion of investigations, the respondents be remanded for a period of 21 days at the following designated police stations. The first respondent, that is John at Mdaiga Police Station. The second respondent, that is Mark at Gigiri Police Station. And the third respondent, that is Francis at Capitol Hill Police Station. The third order is that electronic gadgets, that is mobile phones, seized to be subjected to forensic examination. And the fourth order is any further orders this Honorable Court may deem fit. The grounds upon which the application is premised are supported by the affidavit of number 24-1240 Inspector George Karanja, deponed on 30th of June this year, as summarized as follows. 1. That investigations were ongoing over 4 criminal offenses under the Penal Code, which include arson, stealing, housebreaking and burglary, and malicious damage to property. 2. That the respondents were arrested on the night of 27th of June this year on board a Mombasa-bound motor vehicle registration number KCE in an attempt to evade arrest following the destructive events of 25th of June this year. 3. That upon their arrest, a lawful search was carried out and they were found in possession of 6 mobile phones and a black notebook that contained critical information relevant to the investigations. 4. That the investigations at hand were complex in nature, considering the significant impact on national security following the distractions occasioned on 25th of June this year. Hence, the need for detention of the respondents for 21 days, through which they could either be found liable or vindicated. When the matter came up for hearing, the applicant, through the ODPP, reiterated the substance of the application, referring the court to the classic case of Sudi Oscar Kipchumba versus Republic, in which the threshold was set out for this kind of application. The entire application was strongly objected by the defense legal team, led by Dr. Kaminwa, who in summary submitted as follows. 1. That the respondents had been arrested without warrants and detained for more than 24 hours. 2. That they were non-human rights defenders based at Ruaraka social justice movement, hence were not a flight risk as alleged in the supporting affidavit. 3. That they had not been summoned by the deponent, thus could not be said to be fleeing arrest. 4. That there was no justification for the 21 days sought after in terms of a breakdown of the processes needed to be accomplished within the stated period. 5. That the application seeks to deny the respondents their liberty, considering the fact that after the lapse of the period sought, there was a probability that they will be vindicated. Hence, the need for the court to consider where the greatest harm lay. 6. That there had been no annexure in support of the application to justify the ongoing investigations as deponed. Lastly, that the application seeks to infringe on the rights of the arrested persons as enshrined under Article 49 of the Constitution. The present application was brought under Articles 49(1), F, G, and H of the Constitution of Kenya, which provides on the issue of the rights of the arrested person, which is quoted. So it is not in dispute that the respondents were arrested on the night of 27th of June this year, which was a Friday, and booked at Mdaiga Police Station via OB number 5 of 28/6 of 2025 at 01:12 hours. Thereafter, they were arraigned in court on Monday 30th of June, this being the earliest court day. It was here that they were duly informed of the reason for their detention, continuing. Hence, my view that the provisions of Article 49(1), F and G of the Constitution had been duly complied with. Section 36 of the CPC allows for the officer commanding a police station in situations where an arrested person cannot be presented in court within 24 hours to be released on reasonable bond or bail for offenses other than murder, treason, robbery, violence, and attempted robbery with violence, unless the offense appears to be serious in nature. On this basis alone, the respondents were entitled to be released on reasonable bail terms pending the arraignment in court, since the offences in question were not amongst those mentioned by statute herein above. However, the section also allows the officer in charge to assess the seriousness of such other offences, and it was on this basis that the respondents herein were detained and arraigned to court at the earliest date. Therefore, the issue for determination is whether or not the respondents were suitable to be released on reasonable bond or bail, or if there were compelling reasons to have them remain in pre-charge detention. And Section 39, Section 36A, 4, 5, and 6 of the Criminal Procedure Code provides the guidelines for the court in answering these questions, and has been quoted in the ruling. And the defense counsels firmly submitted on the need for the said respondents to be released on free bond, as there were no compelling reasons for their further pre-charge detention. On the other hand, it was the applicant's submission that the respondents were properly linked to the chaos and distractions witnessed on 25th of June this year, which resulted in widespread fear and compromised public safety and national security. They further believed that the respondents had financed the individuals who infiltrated the subject demonstrations, and lastly, that they possessed materials clearly mapping out their illegal activities. The first question for consideration is whether the respondents were flight risk. The answer is in the negative, because it was admitted by both sides that the trio were known human rights defenders based at Ruaraka Social Justice Movement. Thus, in my view, persons that will honor summonses issued to them. The fact that they were arrested on board a Mombasa-bound bus did not, in my opinion, translate into an act of fleeing arrest, since they had not been summoned by any police officer. The second question is whether the respondents may interfere with the witnesses. To begin with, the court has not been furnished with evidence in terms of an OB report lodged by the various complainants in any police stations of the affected areas with respect to the offences at hand. That means that at the time of these applications, there are no witnesses likely to face interferences from the subject respondents. The third question is whether the respondents might interfere with the investigations. What came out clearly from the affidavit in support was that the investigating officer had already secured crucial evidence from the respondents that could, in my opinion, be independently interrogated without any interferences, since they will be in the hands of professional detectives within the police force. Similarly, no recoveries directly linking the respondents to the potential charges were made. Thus, my view that it was too early to conclude that they supported the illegal activities that affected the demonstrations of 25th of June. Further, in the event of new information tilting towards any such interferences, the applicant was at liberty to move the court on a need basis. At this juncture, we turn back to the Sudi case, Supra, that was majorly referred to by the parties regarding the tenets for consideration by the court in determining whether the present application was merited, and it has been quoted there. You'll get a copy of the ruling. Comparing the standards in that Sudi case herein above to my analysis of the case, I am not persuaded of the existence of exceptional circumstances at this stage that will translate to the respondent's pre-charge detention as the only avenue towards the path of justice. In the same vein, the framing of Section 36A of the CPC implies that the orders sought after were at the discretion of the courts, with a lot of emphasis being laid on the respondent's right to liberty, as read in subsections 4, A, B, and 6 respectively, as opposed to the detention clause referred to in subsections 5. Subsequently, I find no merit in prayer B of the application, thus the same fails. Turning to prayer C, on the subjection of the seized electronic gadgets to forensics examination, it is my view that this prayer was merited in that the information to be gathered from the said process will inform the direction the investigations will take. Ultimately, this will lead to the respondents either being found liable, thus charged accordingly, vindicated, or result in the capture of the actual perpetrators. In conclusion, I hereby order that the electronic gadgets seized from the respondents be subjected to forensics examination. Lastly, and in the interest of justice, while having regard to public interest, order, and national security, prayer D of the application is allowed in terms of Section 36A(6) of the CPC, that pending the completion of investigation, it is hereby ordered that the respondents be released on cash bail of 200,000 with a contract that the respondents report to the investigating officer at Mdega Police Station every Mondays and Thursdays at 9 a.m. to facilitate the conduct of the investigations, that the respondents desist from utterances and activities akin to those under the subject investigations. This matter shall be mentioned on 23rd day of July this year for further direction. It is so ordered.
He went further and said, it's difficult for us to continue doing pro bono work when we are so broke. I completely agree with that. The lawyers are making their significant contribution in upholding the Constitution of the Republic of Kenya without any money. But may I add respect to the owner? We are not the only people who are broke. The entire country is broke. There's no money. I'm saying all these things, Your Honor, to plead with you to reconsider the cash bill of 200,000. Asking for 200,000 shillings, Your Honor, is now like asking for 1 billion shillings. We have no money. And this subject here cannot get money of that magnitude of 200,000. Your Honor, I'm committed to the Bible. I go back to the Bible to remind you very respectfully and be merciful. Reduce the 200,000 shillings to 50,000. We can go on a begging trip to get 50,000 shillings for each one of them. 200,000 shillings of money. We cannot do this 200,000. With those who have remarks, Your Honor, I beg you to review your orders and reduce 200,000 shillings, 50,000 shillings. Because of the prevalence of poverty that is now in the country, it affects the prosecutors, it affects the lawyers, it affects the common people in the streets of Nairobi, and seriously affects our people in the rural areas. Human rights defenders, Your Honor, the name sounds big, but they're not given. They don't understand it. If they get something very big, very small sum of money, they are not in our salary. It's the people who have volunteered to uphold the constitution of the country, to ensure that we have a civilized society around. They are like the priests in their own way. Again, with those 2 remarks, Your Honor, I appreciate with you sincerely from the bottom of my heart that you reduced the figure from 200,000 shillings to a more moderate figure. And they go even further, Your Honor, you still have the option to give them the personal phone. They will not be free. No one can leave Kenya, Your Honor. There is a saying in some quarters, you know, a young man or a young boy at school, that when you are tired of Kenya, you are tired of life. Nobody can leave the country, and definitely people with a commitment to the country, you saw them sing as they come in. They are committed to this country. They are not the kind of people who leave Kenya, that they are going to Somalia, they are going to Sudan, or they are going to Liberia or people in West Africa. They are committed sons of Kenya. They have no any other country. That's all.
Your Honor, as I fully associate with the comments of my senior, I'd like to plead with the court to recall the words of Watcher in the Shakespeare play of The Merchant of Venice, where she talks of the quality of mercy, Your Honor. And in the spirit of that passionate speech delivered by Watcher, we pray that even though we are after justice, let the same be seasoned by mercy. Let this amount be reduced. Because, Your Honor, 200,000 is akin to telling them to wait in the cells. They cannot raise the amount, Your Honor. we do pray for mercy.
Did you in response?
Your response and praying that the town will remain as set by the court. I believe the court has considered all factors. We agree with the court that the terms as given are sufficient, considering the issues raised in the application relating to national security and the likes. I will also be requesting that probably informing council that if there is any review of the decision, then that is to be made before another forum, which is the High Court, and not the court that already pronounced itself. With regard to your directives on where the suspects are supposed to attend, if they are able to satisfy the bond terms, we would request that it will be Central Police Station. That is where the lead investigations are being done. And in the event that they are not able to fulfill the bond terms as set by the court, we will be requesting that they be remanded to the Kibera station. That will be all.
May I ask something? Your Honor,
Briefly, Council.
people, sorry, I will say sorry. Your Honor, my learned friends who are appearing for the subjects are patriotic sons and daughters of Kenya. They are rendering pro bono services. The subjects also are pro bono sons of Kenya. They are not prepared and they will not, Your Honor, leave the country. Speaking on my own behalf, Your Honor, if I were to get information that I'm trying to run away from the country, I would stop hearing for it. There are people who volunteered to render pro bono services in the name of human rights. And they have done a sterling job educating our people in their human rights under the current constitution. And I repeat to you very, very respectfully, Your Honor, the answers that we are facing on the problems we are facing in the country are not to be found in the activities of the young people. The young people are our sons, they are our daughters. It is us who are adults who have to find proper solutions to the problems. They are still at the stage where people can say to them that if you do not protest, they will not protest. Behave yourself, they will behave well. And Your Honor, again before I sit down, you have made a very, very significant contribution to the jurisprudence of the country and to the hearing process. I beseech you, as an elder, rise to the occasion, give them free bond, or ask us to go to the streets of Nairobi and beg for 50,000 shillings from people under the umbrella of the spirit as we are doing by Mzee Jomo Kenyatta, spirit of our Africa. To uphold justice, to uphold fairness, to uphold equality, and to uproot arbitrary loose talking by those who are in public office, and to show to them that We can only save Kenya if we act together with the young people and continue to respect them as our sons and daughters. They have a contribution to have to make, they have significant to make, and the majority of them are unemployed. And all that they are begging us to do is to make reasonable, mature decisions to make sure that they have got some mugali on the table and they can be able to live in a decent manner like any other person. And not to use the criminal law like the way I understand the Prosecution to punish them. That would be very, very wrong. We should not use the criminal law. We should not use the criminal procedure. We should not use the law of residence to punish them at all. The answer is in dialogue. Let us talk to them. And they will stop doing anything like this one. Let us find jobs for them. Let us find good places for them so that they are decent people. They don't live like dogs in the streets of Nairobi.
By the ODPP, they can then report at Central Police Station on the Mondays and Thursdays. And then on the issue of the review of the bond terms, I concur with the ODPP that it has to come through now an appeal of this ruling because so many factors were determined in relation to that bond term. Therefore, I cannot review it at this moment in time. Yes, you'll get.
Forward is justice forward! Forward is justice forward! A luta continua! A luta continua!
Tumeconfirm hiyo pesa inatumana. Hatutaki wengine sasa tuwe kwa shida zingine. So, twendeni tulipe hiyo pesa. Brothers wetu wa Kibera. Pesa inatumana. Power!
Thank you very much. My name is Eric Murioki, one of the defense advocates in this matter, instructed by the Law Society of Kenya. I'm accompanied by my colleagues here, James and Miriam, and other advocates are in court. They're handling other matters. So the first thing we want to do is to say thank you to the judiciary for upholding the rule of law today. Even though the bail terms set have been a bit harsh, we appreciate the ruling of the magistrate. It was very well reasoned. She has actually dismissed the application by the prosecution that was seeking to hold the 3 human rights defenders for 21 days pending investigations. The magistrate has found that there were no extraneous circumstances that would lead to them being held pending investigation. The magistrate has also found that those allegations that they were fleeing from the jurisdiction are not true, they are baseless, and the mere fact of being in a bus going to Mombasa does not mean that someone is fleeing. The magistrate has also ordered that the gadgets which were seized from the 3 be subjected to forensic analysis to determine whether at all they were involved, and I am very sure that our clients will be exonerated at the end of that event. So what I want to also talk about is this habit that the police and the prosecution has adopted in Kenya, whereby they arrest someone without having conducted any investigations, without any evidence, and then they come to court so that the court can sanitize that illegality of someone being held without any reason for being detained. We are appealing to our judiciary everywhere in this country to reject the sanitization of such behavior. The correct way should be investigations first, obtain evidence, and then if that evidence is enough, forward it to the ODPP so that the ODPP can charge. These attempts to arrest people and then seek for days to hold them are an intimidation tactic that cannot be accommodated by the Constitution of Kenya 2010 that we Kenyans gave to ourselves. That Constitution protects the liberties and freedoms of all individuals, including people who are said to be suspected of having committed any offenses. So for that, we are grateful to the court today and to the judiciary, and we say that as the public, as lawyers, we stand with the judiciary, and we pray that the judiciary continues to uphold justice, because justice is our shield and defender. Asanteni sana.
Justice is indivisible.
Oh, okay. Yes, my name is Wanjira Maina. I am an advocate on record, appearing together with Eric and other lawyers from the Law Society. I think my colleague has said everything that needs to be said, that the magistrate has found that there was no proof at all to continue holding the 3 human rights defenders. Whatever arguments that were being made by the office of the DPP that investigations are being carried out, she has found that, for example, there were no OBs presented to her as proof that there were complainants. So there was no witnesses to be tampered with, as was being argued by the office of the DPP. So I think my colleague has said everything that needs to be said, that the magistrate and the judiciary has showed that truly the way to peace and security in this country is through respecting the rights of even those people that are being, being brought here and they are being asked to be incarcerated. The way to peace and security in this country is ensuring that everybody's rights to a fair trial are upheld, which is what she has done today. So there's not much else to be said. We are waiting for our clients to be processed, for their bail to be paid and for them to be processed, because they are free citizens unless there are compelling reasons for them to be held. So that is all there is to be said in this matter.
Okay, I'll give it to you so that you can also give us a quick recap on the instruction that the magistrate gave.
Well, my colleagues have pretty much summed it up. I am James Ongamo. My colleagues have pretty much summed it up. The only thing that I'd appeal is that we know who has hired goons. It's with you media people. We have not seen them being arrested. We have not seen them being charged. We pray that as they continue arresting human rights defenders, that we shall also see them arrest these people who are hiring goons. I will not name names, obviously, but we all understand who is hiring goons in this city, and we pray that justice shall be seen. That's all. That's all.
A quick recap on the instructions that the magistrate gave when releasing.
Well, the magistrate gave instructions. She told them, one, they should desist from activities that have brought them here. I do not know how they will desist because a human rights defender is a human rights defender. She also told them to report to the police station every Monday and Thursday of the week. And the cash bail is set at 200,000. We are struggling. We are struggling to get this cash bail, but we are indeed hopeful that they'll be released today. Yes.
Thank you. And you still hold that your clients are innocent?
Our clients are totally and absolutely innocent. We do not understand why they were arrested. We saw them in a peaceful protest. We acknowledge that there were goons in the city. We know that the person who had we know who had the goons in the city, but our clients were not related to the goons, and they are absolutely innocent. That's our maintenance. Yes.
When are they being the mention of the case?
The next mention of the case is on the 23rd of July, 23rd of this month. Yeah.
Thank you.
Okay. Okay. Sasa?
Going to save us, then we are going to fight for ourselves. We are going to continue fighting for ourselves until we remove these people, these insensitive, greedy and corrupt leaders who are in power in Kenya, who have been in power for 60 years, making the lives of Kenyans miserable, hopeless, and desperate every day. So